I was giving people desserts.
Is it not
Promises?
promises?
Okay.
Stick to our word.
Hi. So, hi everyone, and thank you for joining us for this branding and licensing in the e-commerce world. It's part of our tech transformation series. It's great to have you here. Rest assured, you're all on mute, and we can't see you either. You can only see and hear us at this point. At the end of the presentation, there will be an opportunity for Q&A, and you'll find that functionality at the bottom of your screen. So we'll start off with a very quick introduction for those that don't know me. I'm Jason. I kind of lead the soft IP team here, if you like, which obviously includes branding. And I work a great deal with Rachel.
Yes. Hi, everyone. My name is Rachel Dunning, and I'm a solicitor here at HGM. So I work with Jason in the IP team and also work across the firm with the media and technology contracts.
So I thought I would just start off with a very quick 2 seconds, literally, of who we are for those that don't know us. So we were founded in November 2007. We're now a 6-partner firm, around about 27 people in total. The reason that we set ourselves up was that we saw an opportunity in the market, really, between those firms that knew IP inherently and knew it very well, and between those commercial firms that knew the commercial world very well. And so what we wanted to do is set ourselves up in a little niche with, as a firm that knew IP extremely well, but also were able to commercialize that IP. We're able to work on the innovation of that IP and making, basically, to tell the truth, making money out of that IP. But we are at heart really a corporate and commercial law firm and everything that goes along with that. It's just that we specialize very heavily in tech, media and IP. So in terms of what we're talking about today, the role that we occupy within the firm in terms of advising clients on IP creation, IP ownership, IP registration and enforcement. And of course, if you think about generally taking a product to market, then you're talking about general consumer law that goes along with that. So things like the food code, if we're talking about food product, or you're talking about the FTA or advertising or that kind of thing, basically everything you need to do to take a product to market. So I'll now hand you over to Rachel, who's going to kick us off on trademarks.
Great. So thanks, Jason. So before diving into discussing some of the challenges facing businesses today and how to use trademarks effectively as part of your brand strategy and taking a product to market, I thought it'd be good to just understand a little bit of the history of trademarks, just the basics of trademarks. Trademarks 101. So trademarks have been around for a very long time, back to the caveman type days. But trademarks, as we know them now, became more prominent in the Middle Ages with the rise of guilds. So for organisations of merchants and craftsmen who began to use what we would know now as a trademark as a way of identifying themselves and identifying the work that they produced. If you look at the legislative framework, New Zealand first adopted a consolidated framework in respect of patents, designs and trademarks in 1908. The current legislation that we're working with for trademarks was enacted in 2002, so might be due for an update sometime soon. So what is the purpose of a trademark? Well, traditionally, it's pretty basic. It was to denote trade origin. That is, you would use a trademark to distinguish your products and services from those of a competitor. But going hand in hand with that, it's also become a way of denoting quality. That is, a guarantee of quality. If a customer sees those products on the shelves, they know what they're getting or what they're not going to get, depending on what it is. So this means that through the use of trademarks, you can develop a reputation in the marketplace, and consumers can over time begin to identify that trademark, not only as being a product or service produced by you, but as a certain quality that you provide in that brand. This means there's sort of an advertising role that's been given to trademarks as well, which has inherently increased their intrinsic market value. A good trademark and the reputation and goodwill that can grow with that trademark can completely change the perception of a product or service. So it's really important to make sure that you think about your trademarks in terms of your overall brand strategy and your advertising approach. We talk about the purpose of trademarks, but what really is a trademark? Well, at a basic level, it's a sign is a sign that's capable of being represented graphically and distinguishing the goods and services of one person from those of another. In terms of what is a sign, well, the Trademarks Act gives a little bit of guidance, and it's quite an inclusive definition. So you get the standard things, for example, words and logos, which is what we're used to seeing. But trademarks can also include colours, shapes, smells, tastes. Those, of course, any potential combination of those are potentially registrable. So there's a lot of things that you can potentially put out there as your branding and own them. I've got a few examples there on the screen of trademarks that show just exactly what they can do. For example, for Word, the All Blacks. Now that's obviously registered for a wide range of things. But if you say All Blacks anywhere in the world, nearly anywhere in the world, most people would immediately associate that with New Zealand's rugby team. Similar with Mick Delivery. The mere inclusion of the word Mick in there immediately creates an association in a consumer's mind with McDonald's. Similarly with logos, the silver fern. Most people would have seen that on the All Blacks jersey. Again, creating an association without any requirement for words. We've also got McDonald's, the golden M arches. We've got the Lion Brewery's lion roaring symbol. You could see that in a store, and most people would immediately assume that there's some association between that product and Lion Breweries. Shape is an interesting one. On the screen, Coca-Cola. They have trademarked the shape of their bottles. And it's not until you stop and think about it that you really notice just how unique the shape of their bottles are. A lot of soft drinks have similar shapes, but none quite have the same shape as that glass bottle of Coca-Cola. You also have other products. For example, the Tabasco bottle, the skinnier base, the skinnier top with the triangle logo. I know, but I personally, if I see that on the kitchen table, I would think that was Tabasco. Over time, that shape has managed to build a reputation such that you don't even need to have any words or logos on there. The shape alone can identify the brand. Now, colour is quite a difficult one, as you can imagine, to register, because really, if you think about it, who should get to have exclusive rights to use a colour as part of their brand? Now, of course, we do have some examples. Cadbury, they own the purple colour of block chocolate. And if you see purple on chocolate bars, you're likely to assume that there is a link to Cadbury. BP owns the rights to the colour green in certain instances. For example, there are limitations on the registration in that any person has the right to use the colour green on the actual hose of unleaded petrol, because that has too much genericism to be able to be owned by BP. But in terms of the overall brand of the store, BP can have that colour. Now, if you think about these and think back to what I said in terms of what is a trademark, the requirement for graphical registration of representation of the sign may act as a de facto barrier to registration. Obviously, the things you can see on screen can all be graphically represented. In terms of colour, you have the Pantone scale. But if you think about things like sounds or smells or tastes, how do you describe that? How do you put down in words or describe in some way what that sound or smell or taste is that can differentiate it specifically from that of a similar product by a competitor? So that's what is a trademark. Now, we all know that you can register a trademark, but do you need to register a trademark? Well, in short, no. Trademarks don't have to be registered, but would you want to register a trademark? Probably yes. So if you're thinking about things like protecting your brand, building goodwill in that brand, and defending your trademark from your competitors, the rights that you get from registration really now dominate as the main vehicle to be able to do that in any kind of easy way. Because the Trademark Act gives a clear path for protection, offensive action, and defensive action of your trademark. If you don't register a trademark, you can still do this, but you're going to have to rely on other legislation and common law, such as the Fair Trading Act and the tort of passing off. The difficulty with these is that you're going to have to prove sufficient reputation and confusion, which, while likely possible, is going to be a much higher standard to reach. Now, Jason's going to cover off the benefits of registration a little bit later in a more specific context. But some of the things that are obvious benefits to registration include the exclusivity to use that you get upon a trademark registration, that legal protection to deter others from using your brand or imitating your brand, and it just adds value to your business that can increase over time as the mark becomes established in the marketplace and develops a reputation. That's commonly known as goodwill, but the trademark itself can develop value. If you're looking at registered and unregistered trademarks, you also likely see often the R symbol that you can see on the slide there, known as the rondel or the little TM sign. Now, if you've got a registered trademark, you're allowed to use the rondel sign. If it's unregistered, you're not. You can only use the TM sign. Of course, if you have a registered trademark, you don't have to use the rondel sign. You can use the trademark. There's no real reason why you would do either except for to flag out there that it's a registered trademark. Why would you use the TM sign? Well, a lot of people would use it as a way to claim ownership, essentially, over that brand, as a way to let others know that you're trying to say that this is unique to you. Does it do anything? Well, it may in certain circumstances. Now, in terms of the registration process itself, registration of trademarks is a territorial process. So that means you need to register in each country or jurisdiction where you want to or need to have protection. Registration of trademarks in New Zealand is dealt with under the Trademarks Act. Essentially, you apply for your trademark. That trademark is examined by the Intellectual Property Office of New Zealand against certain criteria. And if it's not opposed or you don't face any issues that you can't overcome, you get a registration. When you're applying for your trademark, you need to apply for it for protection in respect of the goods and services that you intend to actually apply that trademark for. Getting the goods and services correct is really important because this defines the infringement rights that you have. This is something that we can also help you with. So if you have any questions, feel free to come and ask us. The classification system is for the classes. So there's 45 classes overall. This is broken down into 34 classes known as goods and then 11 classes that are known as services. This classification system is based on an international regime published by the World Intellectual Property Office, known as the NICE classification system, which is good because it means that internationally there is a recognized system of defining the goods and services. So each jurisdiction may have its own way of interpreting that or applying it. In terms of the type of classes that you might get, these are broken down into things, for example, like software and related goods, hardware, retail and wholesale services, advertising services, financial service. Each are given their own class of related goods, and you can apply for as many or as few as you like that you intend to use. If you do succeed in getting a trademark, well, you can essentially have it forever, provided that you continue to use the trademark and you pay the registration fees. You are given registration in blocks of 10-year periods taken from the date where you're deemed to have been registered, which is when you applied for your trademark. In terms of actually registering a trademark, I mentioned earlier that in addition to being able to be represented graphically, it also must be able to be capable of registration. So there's a number of objective and relative grounds that must also be met when you're applying for a trademark. The trademark obviously must be capable of distinguishing your goods and services from those of another. The trademark you're wanting to use cannot be so inherently generic in relation to the particular goods and services, such that there's no way that that trademark could actually denote the trade origin of them. The trademark also must have distinctive character. you can think of it like, are other traders likely to want to use the same or very similar trademark in connection with their own goods and services in the ordinary course of a business, and it's reasonable to expect for that? For example, is it so descriptive of what the goods and services are that it would be unreasonable for one person to have exclusive rights to use that trademark? There's a lot of crossover there with distinguishing it, because if it's so descriptive, then it's unlikely to be able to distinguish where the trade origin actually is. It's often referred to as, does the trademark communicate a badge of origin, which is a good way to think about, does that trademark identify you as a company and what you produce? The trademark also must not be just generally descriptive, so it can't essentially describe the kind of goods, the quality of the goods, the geographical origin, when those goods and services will be delivered. Quickly, for example, can often be problematic. You need to think about, would an average consumer regard the trademark as a normal way of describing those goods and services? There's also a few additional things that also get taken into consideration that don't delve into just the overall nature of whether a trademark's capable of registration. For example, the mark can't be deceptive. It can't be a mark that's going to deceive or confuse the public as to what either the products itself or in relation to other products in the market. It mustn't be contrary to New Zealand law. It shouldn't offend a large portion of the public. And the application must also not be made in bad faith. So you must actually have the right to apply to own the trademark. Okay, so I think we can talk about some benefits of registration.
Thanks, Rachel. That's great. So we're going to move now to just a couple of slides on the benefits of registration of a trademark. And one of the words I want to pick up on here on what a trademark gives you is a trademark is an exclusive right, and it's not a monopoly right. And that's a really important distinction. Patents, in terms of IP rights, are true monopoly rights. If you have a patent, no one can do anything that infringes, i.e. falls within that patent at all, irrespective as to whether they've come up with that idea or that process, that invention themselves. If you've got a patent, predates what they're trying to do. However, because of the trademark system exists within certain classes, it's perfectly possible for two people to have a brand and only have the exclusive right to use that brand in respect of their own particular goods or services. Now, the most often quoted example of this is the Ritz Hotel and Ritz cheese crackers. Now, they're both famous brands in their own right, but no one would expect the hotel to be producing crackers for cheese, and no one's going to try and book an accommodation with a biscuit manufacturer. So therefore, they're completely separate brands. No one sees any connection between them, but they only have the exclusive right to use in respect of those goods. So that makes you think, really. So what is your brand? A brand can be your trading name, it can be your business name. An important point here that people often wonder about is, does it have to be the same as your company name? And the answer is no, because what your brand is the element that you trade under that actually is visible to consumers, that consumers draw a connection with. So if you think, for instance, a good example here in New Zealand, up until very recently, the two supermarket owners here, neither of them had supermarkets which were the same as the ultimate company that owned those supermarkets. They both had separate trading names, and those trading names very popular, very well known, and they drew people to those supermarkets, but they were in no way really connected in terms of people didn't realize what probably the parent company of those brands were. Some people, because of the advent, if you like, of the internet many years ago, and the reason I say the advent is because I'm going to use an example here from many years ago, some people actually adopted their domain name as their trademark. So if an example of when kind of internet startups were making loads of money, the lastminute.com, the hotel and accommodation provider, they actually adopted their domain name as their brand, and that's perfectly legitimate. It tells people exactly where to go on the internet to find you. So in fact, pretty smart move actually. Now, of course, a lot of people interact with the world, with the consumers via an app. And the constraints of an app, you've got a very small kind of size of your fingernail, little picture there on your phone. It means short names are now in favor. The app name can often be the only brand that someone interacts with consumers with. For instance, TikTok, very short name, fits within that tiny little graphic on your phone, but no one actually knows who owns that company. In terms of general awareness of who owns that, they just know it as TikTok, they know it as the app. Okay, so moving on to some other benefits of registration. Trademarks, when they're registered, ultimately sit on a publicly searchable register. So most countries around the world will have a trademark register which anyone can access. There are still some countries that don't, either for technological reasons or because English isn't the main language, so us as English speaking simply can't access it. So when you're looking to launch a product or a brand or a service, one of the first things you should do is look to see if anybody else has a trademark, has a brand which they're claiming ownership in, which is similar to yours. And of course, this publicly searchable register makes it very easy for people to do that. In fact, there's really no excuse to not do it if you're looking to brand a product or service. So what you've got there is your trademark registration acts as a very visible deterrent to people. In other words, I already own this brand in this space, so if you're thinking about coming into my space, don't use anything which is the same or similar to what I'm doing, because A, I'll be able to stop you, and B, you really want to create your own goodwill. Don't come anywhere near my goodwill, because I've spent money and time building that reputation. So ideally, when you are looking to launch a brand, you would undertake a clearance search, but that's expensive, especially if you're looking for many countries around the world. So one of the benefits of the registration process here is the individual IP officers, as part of their examination process, which they undertake in respect of all trademarks, they do that search themselves. So they will undertake a search for a brand which is the subject of an application to see if there are any same or similar marks. Now, despite the fact that most registers do that, what they do with the results of that search does differ from territory to territory. In some territories, if they find a similar mark to the application, they will actually block that application from proceeding. They'll say, no, sorry, we think it's too similar to an early mark on the register. It's going to lead to confusion, so we will not allow registration of that. So they actually create the block by the office themselves. Other countries take a slightly different approach in that if they find a similar earlier registered right, they won't block your application going through, but they will notify the earlier rights owner. So they will say to the earlier rights owner, hey, look, might be interested, but we've just examined this application. We think it's similar to yours. There's no obligation for you to take action against it. It's completely up to you. Now that, of course, is pushing that cost burden down to the small or large businesses that are the prior rights owner. And then what that does is that means that if you like, the government in those countries, those IP offices, that's actually paying for a kind of a pseudo clearance search for you. So providing you have the time to file a trademark and let it go through the application process before you want to launch your goods and services, the IP office will undertake a search for you. Now, of course, their searching criteria may be very different to what a professional searching organization would look at. Also, they don't look at unregistered rights. So if there's somebody out there with a brand reputation who has never bothered to register their brand, the IP office really doesn't care about that. It doesn't look for that. It'll only find registered marks. And of course, another caveat to that is often brand owners see things within their brands when compared to another application, which to them does make them similar. There are competitive commercial reasons as well for opposing. So even though the IP office may clear something, it doesn't necessarily mean that you won't get a trademark opposition or a trademark objection from a third party. Incidentally, in terms of that examination process, where the office does stop your application going through if there's an earlier right, what that registration normally then gives you is a defense to trademark infringement. So for instance, here in New Zealand, the office does a thorough search and it will raise objections in respect of similar marks. And that will give you a registration at the end of the day that acts as the defense to trademark infringement. If we compare that, for instance, to the European Union, where they undertake the search but do not actually stop the application from proceeding, only warn the prior rights owner, that does not give you a defence to trademark infringement. So it's often said that a European trademark is a sword rather than a shield, i.e. you can use it to attack someone, you can use it to sue somebody for trademark infringement, but you can't use it as a defence to trademark infringement. Finally, another benefit that goes along with that trademark registration process is that all trademark registration processes, once you've gone through what the office wants to examine and look at, you get what's called an opposition window. And this is where the trademark is published in a journal. Now, of course, it's an online journal, which allows any third parties the chance to object if they see that brand as not capable of registration for any reason. They might think it doesn't function as a trademark, or they might think it's too similar to their own. But that opportunity for third parties to object, that bringing it to their attention, means that you're perhaps there also giving people the chance to object early before you actually start selling in that country or start pushing your services into that country. So again, you're kind of getting a pseudo clearance search there, which should give you some comfort as to your ability to use in that country. So Rachel's now going to talk about how we go about getting rights in various countries.
Great. So, as I mentioned earlier, trademark registration is a territorial process. So you're going to have to think about which territories do you actually want to register your trademark on? Where will you be selling or providing your goods and services? So in New Zealand, as I said, that was via the IPONS process. But if you're looking as a New Zealand company, or indeed any company that's based overseas, to register your trademark in a country that's not your home country, well, there's two basic routes that you can take. So there's something called the Madrid Protocol. What this means is that New Zealand trademark owners can file what's known as a base application in New Zealand, or if you're based, for example, in Australia, that's where your home country is, in Australia. And then you can use that base application to file a Madrid application and designate one or more overseas jurisdictions where you also want to seek protection at the same time. Now, each of those jurisdictions also have to be Madrid Protocol members. Now, alternatively, you can file what's known as nationally, i.e. via a local agent. Same as if you're filing in New Zealand via IPONS, you can file directly with that local country's intellectual property office. You may choose to do this route where the country isn't part of the Madrid Protocol, so you have no other option. Or there may be some specific requirements that just make it a more practical approach, or there may just be another reason. Which sort of leads to, well, how do you pick? Do you go via the national route, or do you do the international registration via the Madrid Protocol? Well, if we look at a Madrid Protocol option, this could be quite cost effective rather than using agents to file in each local country, depending on the number of jurisdictions that you're wanting to seek protection in. If you're going to go for any number of jurisdictions, but for example, say there's 5 to 10 countries that you just know that you're going to be launching in those, so you may want to file right now at the same time. This is an easy, cost-effective way to do so. This also sets up an easy process to add on jurisdictions later once you've already got the process started. But it can also be a much slower process because you have to go through the multiple steps. You have to have your base application in New Zealand, and then the applications are still examined locally by each local intellectual property office, and so may be subject to opposition or any other issues that may arise. And at that stage, we may have to engage a local agent to assist. If you look at the national approach, something there may be a benefit there is you can sometimes get free advice from an agent. They may be willing to, give a little bit of help of defining your goods and services, or if there's particular documentation required that needs to be notarized or legalized, they'll be able to give you the guidance for where to go. They could also help with pre-clearance searches, and there's also often, not often, in some instances, it's a quicker route to registration. However, it is likely to be more costly, partly because you're having to engage a local agent and they will have their own fees on top of the fees from the intellectual property office, but also because you're just not going to be able to get that bulk discount that you may achieve from going via the Madrid route and designating multiple jurisdictions at the same time. So which way do you go? Well, you're going to have to weigh up the benefits and negatives in your particular circumstances. What are you after? Do you need world domination cheaply? Then you might want to go the Madrid route. But if you need something quicker, or to be confident that the process is going to go very smoothly or as smooth as possible, or there's particular tricky documentation, then you may just want to go to each of the countries and get a local agent to advise you exactly what you need to do. If you have any questions about that, as a local agent, we can also help be that middle person between the national agents and help smooth the process through as well. Which of course leads to where you might want to register. Jason?
Thanks, Rachel. So where to register? Now, I think the key point here is, do you need to register everywhere? I would say you don't, unless you're a pharmaceutical manufacturer, unless you're Apple, unless you're a good which is truly used, or indeed a service that's truly used in every country around the world, or you have designs on it, maybe you're McDonald's, then I suspect you don't really need to register everywhere around the world. I think you need to be choosy and you need to choose wisely. If we look at those in terms of maybe a services delivery and a goods delivery, think about if you're an online services provider, think about your main site. Where are you delivering those services from? Now, if it's the .com, then in theory, anyone around the world could look at that site and think, oh yeah, that's kind of the global universal .com that everybody has if it's a site that's intended to point to the world. So they may try and access that site, but unless your site is in their language, unless the site takes currency from that country, then it's very unlikely that people are actually going to purchase those services from your site. Of course, if you wanted to point your services to a specific country, then you add the currency, you use the local language, or maybe even you get yourself a local domain name, and that's really saying, hey, I'm targeting you as a country in terms of where I want to sell my services. Now, even though you're an online services provider, you may well have a relationship with a local, say, software implementer in that country, because people do need some level of local software setup in order to access your online services. Now, that, of course, is where you are then asking somebody in a local jurisdiction to go and attend to those services under that brand. So that's a key trigger point there, I think, where you may need to think about, actually, I do need a brand here. And because I'm going to have a contractual relationship with someone in that country to deal with that brand. Now, if you're selling goods, now, of course, use of a trademark includes the manufacture and the sale of those goods. So if you're selling goods into a country, then yes, you certainly do need a trademark in there. Otherwise, you may find yourself infringing somebody else's rights. But then also another important factor there is if you're manufacturing goods in a country, those goods will have the mark applied to them in that country, and that's use of the trademark just as much as selling is. So again, it's very important to have a trademark if you're manufacturing in that country. You've also got to think about who is doing the selling for you. Maybe you've got a local distributor, maybe you've got a local agent. And then again, you're going to have a contractual relationship with somebody in a country to use that brand for you. Now, the interesting thing about that contractual relationship is it will probably have maybe New Zealand as a governing law. Now, enforcing a contract across into a different jurisdiction, which has a different law to possibly the local law, that's not a simple task. That will be quite complicated. The advantage of having a trademark registration is you will be acting with a local right in that local country. So then it becomes a much more simple process of enforcing that. So here we go, where to register. So the key point is not to register everywhere. You've got to think about where's important to you. Where are you actively selling into? But also think about the future. Where in the future do you see your market expanding to? You may well see yourself as setting up a business in New Zealand and then say, well, actually, ultimately, then I'm going to roll out to Australia, really want to sell in the US because I think there's a great market there, and possibly Europe. Right at the start, you then need to be thinking about, well, actually, would it change my brand choice if that market rollout plan didn't really work? Because I could only go as far as Australia, and then actually that brand isn't free in the US and it's not free in Europe. So maybe there's a bit of future planning there that needs to be put into place to make sure that that brand is available in those 4 markets before you take the first steps in New Zealand. A good example of that is the supermarket Aldi, which is an Australian, but it's not here yet. Aldi religiously files all of its brands over here because it operates the market where it has lots of sub-brands. They are all filed over here. So the moment that Aldi wants to come into New Zealand, it can. Its trademarks are all there. They've all been cleared. They've gone through that process of being examined and gone through to registration. So it means it can step into this market relatively easily in terms of the IP protection. The final, just one other point actually in terms of trademark protection is getting a registration is all very well, it does act as a deterrent, but ultimately if you're putting a trademark registration protection into a country where you wouldn't necessarily take action, you wouldn't necessarily sue somebody, or you definitely wouldn't take action, then again, query the cost benefit there in terms of spending the money to get the registered right, when actually you wouldn't necessarily use it if push came to shove. I've just got a couple of slides here on that build on the why to register point. So we've talked earlier on about the benefits of registration. I mean, was the brand cleared? Have you gone through that clearance process? Because that ability to use depends on the clearance, and the registration process does take you through that. So it becomes an early indication of infringement risk. I think it's also important to think about if you've got someone on the ground who is your distributor, who is your local agent, those relationships often work out well at the start, but then don't work out very well at the end. So if you're going to change your local operator, you need to make sure that you own your brand so that you can pick your brand up and you can move it to somebody else and get them to be your local distributor. That's much easier if you've got a registration as opposed to not having a registration. Brand jacking. Brand jacking is when somebody else registers your brand for you on purpose or by accident, but generally on purpose, and then creates some kind of barrier or hassle for you coming into the market. And that is a thing that happens. We've had examples within clients who have gone into a country to talk to people about them becoming a distributor. And lo and behold, during those negotiations, that local operator has kindly registered the brand in their name for the client. That obviously creates a very sour taste in the mouth right at the start of the relationship, but it does happen. So again, get in there first. It's much easier to get your brand than it is to take your brand away from somebody else. And if you're building a business, if you're setting out to create something that ultimately you're going to sell, a few trademark registrations in key countries gives the person who's looking to purchase your business a real incentive that they can actually take that. They can expand into those markets because they know you've got the registrations there, so they can build something big out of the business. So ultimately, that pushes up the purchase price. Just going to talk about some kind of almost additional benefits you get from registration. Customs notices are a key one. Now, people normally think about customs as looking at goods when they come into countries, and that's exactly what they do. But what you can do is you can register your trademark registration with customs. They will then look at goods coming into the country and they will weed out counterfeits for you. They will actually stop them at the border and give you the opportunity to take action against the importer. That's tremendously important if you're producing a good which is going to be counterfeited. An interesting fact as well, in some countries, China is a particular one, is customs will act on goods leaving the country as well. So if you have a manufacturer who puts your brand on the product in the factory, those goods are then shipped to the docks. If someone else owns your trademark registration, they can actually stop those goods leaving. And we've heard of instances where people have created their product, take them to the docks, customs refuse to let them leave, so they have to take them back to the factory, debrand them, then send them to New Zealand and get them rebranded over here. That, of course, is tremendously expensive. I've touched before on distributor sales agent. If you are giving somebody a license to use something contractually, that person, be it an agent or distributor, or even a manufacturer, should be saying, do you own that brand? Show me proof that you own that brand. Give me a warranty you own that brand, and then give me an indemnity in case I infringe by doing those things with your brand in this country. So again, the registration process gives you the comfort to give that warranty, to stand behind that indemnity, because you know that you own the brand. Online selling platforms, social media, they often have hidden within them ways that you can stop people doing things you don't like, be it with your brand or with your products. Facebook, for instance, will take down people who are selling maybe fake products or creating fake accounts, but you need to show them that you own that trademark registration. It's actually a relatively simple process, but it's very, very regimented and tick box process. And basically you need a trademark registration certificate to upload in order for them to take action. And once they're provided with that, they will take action. Is there a regulatory process to do with your services or your goods for which a trademark registration becomes very handy or very useful? Are you in a regulated industry? For instance, a really interesting one we came across only this week actually was a client selling into Indonesia. And it turns out actually the Indonesian body that governs the sale of food want to see a trademark registration or a trademark application attached to that food product in Indonesia. And I never even knew that. But again, that's a reason to get yourself a trademark registration right at the start. Finally, if you want a local domain name, sometimes the registry will want to see that you're maybe a citizen of the country, you have a locally incorporated entity, or another way you can tick that box sometimes is say, look, I actually own the brand in this country, so therefore that gives me a right to a domain name. Of course, that doesn't give you the right to take the domain name off somebody if they've already got it, but it gives you a right to apply for a domain name which is so far unregistered and make it your own. So moving finally to who should register. So having trotted through the benefits of registration, what you have to go through to get a registration, I think it's fairly clear that the person who should own a trademark registration is in fact you. Now, of course, that could be you, the NZ entity that is then selling into Australia or selling into the US or selling into Europe. Or it could be your local wholly owned entity. That's absolutely fine. And that can be driven by tax reasons for that. That's also absolutely fine. Most countries around the world have basically the same rule for who should own a trademark, and it should be the entity that's using it, i.e. the entity that's licensing or the entity that is hands-on using that brand. So whether you set up some intra-group company arrangements to allow that to happen, or whether you actually do have an entity in each country that's using that trademark, doesn't really matter. It's whatever works for you commercially, financially, and from a tax perspective. I've talked about the fact that it shouldn't be your local distributor or agent, and that is really key. Now, what you often see in agreements with local agencies or local distributors is, look, we're going to have this great relationship, but if it does go wrong, you have the trademark registered in your own name, but you promise to give it back to me if this relationship turns to custard and we decide to terminate. It looks great on paper, but that is so not going to work in practice. Again, you'll be talking about an agreement which is probably subject to New Zealand law, which is maybe in Vietnam or some country like that. So then you're going to have to get that contract enforced in New Zealand law in Vietnam against the distributor. Very, very hard. However, trademark registration is subject automatically to Vietnamese law, and so you can then go directly to a local lawyer in Vietnam and say, I've got the right to act here. You don't need to get all convoluted in terms of your commercial arrangement with the distributor. And of course, when you're in a fight like that, it means it's exceptionally hard to take somebody else into that relationship, no matter how bad the incumbent is. So again, you should own that mark. You should absolutely own that mark in those countries. Now that brings us to the end of on the 45-minute mark, which I think is pretty good timing. Now we do have time for questions. If anybody has any questions, then please use the whiz-bang tool. So the question is, noting that trademarks are registered in specific jurisdictions, and if registered in at least one, is it acceptable to use the R denotion internationally? I create the mark material once and use it globally, or do you need to add or remove based on the country of use? Now, this is a phenomenally interesting question, which, believe me, I've worked in several in-house roles, and there was no simple yes or no to this. Some countries take the view that if you have a trademark registered somewhere, then you're entitled to use the roundel everywhere. Other countries don't. They say you can only use the roundel in our country if you have it registered in our country, i.e. taking the very territorial approach to trademarks. Now, if you look at some famous brand owners, we've used McDelivery, and I've mentioned McDonald's in this. If you look at McDonald's packaging, the drinks, cups that come, McDonald's religiously uses the TM. That's because they are very aware then that they've got packaging which can flow from territory to territory. They can produce one kind of packaging. It doesn't need to be localized because anybody can use the TM at any time on anything. There's no law against that at all, whereas you can fall into trouble with the roundel. Now, I must say, I've never in 20 years of practice noticed anybody be taken to task under any local statute for using the roundel, but it's possible. And it's possible that if you're in a business where there are people with a certain gripe against you, that's an easy way to attack you, to be honest. So I would say stick with a TM and go with packaging that you can use across many territories. Second question is, will registering a trademark in Singapore provide a halo effect throughout the ASEAN countries? Not really, to be honest. Because of the very territorial nature, it's likely that anybody looking at where you've registered is going to look on a country-by-country basis. You may well get someone who looks at a mark, finds that a mark's registered in Singapore, and think, you know what, there is no point me going into Asia with this brand because someone's obviously has an interest in it. Even if they haven't registered in the other countries, they may have some use in those other countries. So there may be a very slight deterrent effect. It's possible, but I certainly wouldn't want to rely on that to give you concrete comfort that actually just registering in one territory would help you everywhere. And just one more question, I think. Yes, yes, it's fine to be late to a webinar. That's absolutely cool. Yes, in fact, and that takes us to our closing remarks, actually. Thank you, everybody, for attending today. You will all receive an email after this, which will have the video of this, so you can watch it as many times as you like. I think it will be placed on a YouTube channel, which you will be given access to via a link. There is unusually, because these sessions have not been running kind of on a day-to-day basis, they've been running several weeks, if not apart. There is actually another session in our tech transformation series tomorrow, which is on tech disputes, and that's being presented by Simon Martin and Tim Mahud. So please log in for that. Thank you very much.
Thank you, everyone.